This is the second screenshot video in the area of civil procedure, and it follows the posting, uh, which continues with the typical events in a civil lawsuit. And this posting in this screenshot are related to something known as pleadings. Let me just back up a little bit. If we consider what we talked about and looked at a little bit earlier in the first posting and the video, the so-called pre-suit considerations, what might happen at that phase, and again, there's not a lawsuit that has started. It may well be that a potential lawsuit has been resolved by way of a settlement without the need to even start the lawsuit. This doesn't happen as much, I don't think, today as it may have happened years ago. But a person comes in, they were hurt in a car accident, and the lawyer would first come into contact with the insurance carrier for the driver of the other car, and more specifically would be having conversations with the claims adjuster. And it could be at that point that those conversations and exchange of information lead to what the attorney and her client considers to be a reasonable settlement, and a settlement may be reached and the lawsuit doesn't even begin. We're assuming, however, at this point, if we're going to go forward and talk about pleadings, that a lawsuit has started. Now, and let's just focus. I know I talked about two different kinds of pleadings, but let's focus, let's say, on a breach of contract claim. And if you could just imagine that we're in a hypothetical law firm, a client has reached out to us, has retained us. Don't forget that another pre-suit consideration is where is the legal fee coming from? How is it going to be paid? The lawyer has concluded that the client has a viable claim. The client and the lawyer or our hypothetical law firm are on board. And what's going to happen is to start the lawsuit itself in New York State, and I don't have any written material on this, but I'm telling you now that what we do is we would take a pleading that we're about to talk about, which is known as a complaint. And we also create a document known as a summons, and we file the summons and complaint in the clerk's office, and we do that electronically. Uh, and this is a procedure to follow. You have to learn it on the ground, so to speak. But if you enter into a career in the law, the good news is if you can purchase something on Amazon, you know, you're going to learn quite easily how to do this electronic filing. We have to pay some money to get the case started. And now we have a summons and a complaint that we have filed in the clerk's office. We then are going to cause the summons and complaint to be served on the other party who we're suing. There are ways to do that. Typically, we hire someone known as a process server to do it. And we have started the lawsuit, and we brought the other party into it by the process I described. Now, the pleadings, if I just go up here a little bit, the pleadings are basically what the parties are claiming. If it's the plaintiff and the response to that by the defendant is an answer. So let's just deal with the complainant first. Uh, General rules about drafting a complaint. And again, I know that this is not a skill course. I'm not trying to teach you. I think it would be a challenge online, but teach you how to draft a complaint. If you're going to be a paralegal student, we have a 3-hour course in civil practice, and we have related courses where you'll at least get a sense of what it means to draft a complaint. But basically, the complaint is going to contain the essential factual allegations or general factual allegations that the plaintiff is making against the defendant. The party drafting or preparing the complaint just has to make certain, and this is not rocket science if we were to look at it closely, which we're not in this course, but the allegations of true have to set forth a valid legal theory of recovery. Sometimes in New York, that valid legal theory of recovery is known as a cause of action. So now the defendant goes to their lawyer, his lawyer, her lawyer, its lawyer, and that lawyer is going to have to respond to the complaint with an answer. And what the answer, that's our second pleading we're talking about then. And the answer has to respond to the factual allegations in the complaint by either admitting or denying them. So if you can imagine that there's 10 numbered paragraphs in the complaint, then the answer is going to contain the defendant's response to each allegation in those 10 paragraphs by admitting the allegation or denying the allegation. You'll note that I say that there are 3 different types of denials in New York, but that is true, but we don't have to deal with that now. What we would also see possibly in an answer is what we call in the law one or more affirmative defenses, and what they would constitute, or what constitutes, better said, an affirmative defense is that the defendant has a defense that's not apparent by the denials in the pleadings. Let's assume in this contract case that we're talking about, the plaintiff is suing on an oral contract and the defendant is claiming that under the law, it's the type of contract that should have been set forth in a writing that the defendant signed. So the defendant might raise in his answer the affirmative defense of what we would call the statute of frauds, and that would be labeled as such, an affirmative defense. Then, and I mentioned like in a car crash case, the big affirmative defense one you'll see all the time, it may not eventually have merit, but we raised it at the beginning of the case, is that the defendant is saying, hey, I've denied that I was negligent when I denied that paragraph in the complaint, but I'm also telling you, and this is the affirmative defense plaintiff, that even if I was negligent, you too were negligent. Your negligence contributed to the accident, and therefore, even if you recover, your recovery should be reduced by the percentage of cause that we could attribute to your negligence, plaintiff. And that's sometimes called comparative negligence. Also, the answer might contain what we call a counterclaim. And a counterclaim is simply a claim that the defendant is making against, for relief that the defendant is making against the plaintiff. And that again will be that the counterclaim will be set forth separately with its own separate heading in the answer. And if you can think of the contract case, it wouldn't surprise me that the defendant is taking the position, I didn't breach the contract. In other words, I didn't violate the contract, but you, plaintiff, was the person or entity who breached the contract, and I don't owe you any money, but based on my counterclaim, which I'm alleging in my answer, you owe me money. So that's what a counterclaim is about. If in the answer there is a counterclaim, then the plaintiff has to respond to the counterclaim by admitting or denying the allegations in the counterclaim, and that's known as a reply. So this is just a basic understanding, and we limited ourselves to talking about actions, about what's going on as a typical event. So we say that the parties have exchanged pleadings, and we'll go on to some new material in the next posting and screenshot. Thanks.